Mr. Miller?
Thank you, Your Honor. My name is Jim Miller, and I represent the Director of the Iowa Department of Revenue in this matter. Don Stanley is my co-counsel here. The facts of this case are in 2006, Cable One began offering local exchange telephone service in the Sioux City area over its broadband cable network using a voice over internet protocol technology, commonly called VoIP. The service allowed Cable One customers to receive calls from and place calls over the public switch telephone network, as well as place calls exclusively over its own broadband cable network. The department took the position that Cable One qualified as a telephone company because it was providing telephone service over a line, thereby meeting the requirements of Chapter 433, which allowed the department to assess the Cable One's telephone operating property.
What you consider to be the line that they're operating is the coaxial cable that, say, goes into my home. If I have the phone service from the local cable provider that connects my phone call to their, whatever they call it, the head end, and then goes on, is that the line that you're talking about?
That's correct. In your case, around here, it'd be Mediacom. It would be coming in, it would be their coaxial cable that they carry their video signals with, and the house drops that connect to the house, and ultimately the cable that connects to the handset at a fixed location.
The department's position is that it's a telephone line for purposes of central assessment if it's carrying telephone communications, even if it's also doing cable and internet.
Correct. If it's, we would consider any line that is being used to provide telephone service as a telephone line. That same line could be used to provide cable TV services and internet services, and in fact, that quite often is the case anymore. Not only with cable TV providers providing telephone service, but telephone providers providing data and video service themselves. So the same services go over the same line with quite a bit of regularity.
Counsel, what deference should we give the either the director's interpretation or the adjudication below?
The state board, I think all the parties agreed, the decision was not entitled to any deference at that point. They are in charge with the requirement of making a judicial review of that. The director is the one that actually implements the law and interprets that at the assessment level. But as far as giving the state board deference, the district court and I think all parties agreed that it was not entitled to any.
To the consumer, is this just like a normal phone call, whether it's going over the cable line? Works the same way, rings, use it, dial up, everything the same?
Cable One advertises this as a local access exchange service that's available, unlimited and long-distance service that's available throughout the whole United States. If individual going into a house could not tell the difference if they were picking up a VoIP phone system or a circuit switch system. It's the same handset that's used. It has to be connected to a wire of some sort. Matter of fact, I just switched myself from CenturyLink to Mediacom, and the only thing that I noticed is when the power goes out, I lose my phone service now. Other than that, everything is identical. And that's part of the reason why we believe that there's a competition going on between Cable One and the other telephone companies also. When Cable One offers its telephone service to the public. It is competing directly with the incumbent local exchange carrier, or in this case of Sioux City, that would be CenturyLink, and any other CLECs that would be operating in the area. Anyway, Cable One has taken the position that they are not subject to assessment because their lines are not part of the PSTN. VoIP service is different from traditional telephone service.
Do they send the VoIP service over cable, over cables and wires?
The VoIP service starts out at the home going over the Cable One network.
They're wires. I mean, it's
Yeah,
wireless
yeah,
at one point, but they're wired.
Yeah, it's not a wireless network. It transverses across the Cable One cable network to the Cable One head-end facilities. It's at the head-end facilities that Level 3, which is the wholesaler that is in charge of the interconnection activities to ensure that the Cable One call can transverse and be connected up with the PSTN system.
You're not taxing you're not gonna double tax them first through the cable lines and then through the regular telephone lines, because they have to come in through the regular telephone lines in the end, don't they?
We're not, there's no issue that we're double assessing here at all. The way the system works, when a cable company is set up and starts providing telephone service, the cable company itself is subject to local assessment as a cable TV company. The department doesn't go in and start assessing or double assessing the value of a outside plant, the cable itself. The assessor historically has always picked that up. In this case, what the assets that are added in addition to, that are added by Cable One so they can provide telephone service in the first place are EMTAs, embedded multimedia terminal adapters. And there's other equipment, and Cable One installed about $900,000 of equipment in the Sioux City area exclusively used for the telephone service. Now, I say exclusively used for the telephone service. It's also used for the internet service as well, but it is not being used at all for the video service. None of that $900,000 in costs for new equipment for providing telephone service was ever reported to or assessed by the local assessor. And that is still, even though it can be used also for internet purposes, we would still consider that to be telephone operating property. Now, in situations where you have a telephone company that starts going the other way and starts providing cable service, historically what the department the department would continue to be assessing the entire value of the telephone company, and the local assessor would only pick up that small portion of the equipment, new equipment dedicated to the video service.
What about the telephone company that delivers internet and telephone over the same line, like CenturyLink does?
Yeah, CenturyLink would be assessed as a telephone company.
Even though the internet comes over that line, they're still assessed?
Yes, yes. By putting internet over the line doesn't make that cable or that line exempt. One of the issues that has come up here, and one of the main arguments that I think Cable One is making, is that they are not a telephone company because they don't connect directly to the PSTN. They contract or subcontract with a wholesale service provider called Level 3 to provide that interconnection service. Our position is that Cable One, despite contracting with Level 3, is still providing its customers with access to the public service telephone network, or the PSTN. That access is absolutely essential for Cable One to be providing, the telephone service that it is selling to its customers.
You're telling us all these all these acronyms and things, but tell me in English, I'm not an engineer, how they are operating a telephone line. And what telephone line are they operating? That'd be easier for me.
Okay, Cable One you're talking about?
Yes.
Okay. What Cable One does is when the call is initiated at the premise, customer's premise over a handset, it's the call through these EMTAs are put into data packets that are then routed across.
This EM, whatever this is that part of a telephone line?
No, that's the equipment that's attached to that the Cable One has to attach at the customer premise to convert the voice that has gone from the telephone into make it a data packet switch.
I got it. They're turned to the data packet. Then what happens?
I'm having a little trouble too trying to explain this because it is kind of difficult to imagine here, but it goes across the Cable One broadband network.
Is that a wired line?
That's a wired line. That's not part of the PSTN though. And we would agree with Cable One that that's not part of the PSTN. That's why you need level 3 to connect or make an interconnection between the Cable One system and the PSTN, so the calls can indeed be transmitted across anywhere in the continental United States. The only time that doesn't happen is when it's an internal call from a Cable One Sioux City customer to another Cable One Sioux City customer. In that case, it stays within the system, the Cable One cable network system, and it's still a call in our opinion. That's a telephone call being made from point A to point B that's over a cable line. It just doesn't transverse out onto the PSTN.
Mr. Miller, let me ask you a hypothetical. Let's say I suddenly went crazy and decided I would install my own closed-circuit wireline telephone network. I mean, a completely irrational decision in today's circumstances. And I just built a network that never even connected to the PSTN, but served multiple customers and enabled telephone service throughout Iowa between those customers. Would that be subject to would that be subject to central assessment?
Yes, in our opinion, it would.
So the PSTN is not really necessary to the determination that Cable One is providing telephone service, is it?
The statute that the origination of Chapter 433 was written in 1878, long before the PSTN was even a concept.
And I remember you see these old pictures in the 19th century, and you see these telephone poles with zillions of wires on them. There were all kinds of different networks.
Right.
So the department's position is, if you've got a line, which I think no one disputes you have here, that's carrying a telephone signal, then you're operating telephone service over a line, you're subject to central assessment. Is that it?
Correct. It'd be a same situation. Instead of you, let's say Yonkers Department Store set up a system between Valley West Mall and Jordan Creek and ran a line, in any kind of line, fiber optic cable, coaxial cable, wire, anything, and sold that service to the other retailers in both malls, never went out onto the PSTN, we would assess Yonkers Department Store as a telephone company. That doesn't mean that they're not going to be assessed as a retailer for their commercial part of their property, but we're only picking them up as a telephone company on their telephone operating property. And their telephone operating property would be any of the property, including the line that is being used to transmit the telephone call, the two-way communication between point A and point B. That's what our definition requires. And we don't, the statute doesn't describe the type of technology that has to be used. It doesn't describe the type of wires that have to be used. Everything that Cable One and the district court and everything have said are items that have come about since the statute was passed. The statute wasn't passed at a time when there was a PSTN concept out there. It wasn't passed at a time when there was digital circuitry. It was, you know, it predated all that. I mean, technology has evolved over the years, from analog to digital to now we're into VoIP. And the purpose, the ability for the department to make an assessment is based upon the service that's being provided, which is the service, telephone service over a line, or communication service, distant communication over a line. That's the service that's being provided, and that's the service that allows us to tax Cable One as a telephone company, just on its telephone assets, not the entire company. Thank you.
Ms. Kiser?
Good morning. Chérie Kiser, on behalf of
Can you
Appellant.
pull that mic just a little down? You're not as tall as Mr. Miller.
Thank you. On behalf of Cable One, Inc. and the State Board of Tax Review. Where to begin? This is a straight statutory construction case. It's not about tax avoidance or tax elimination. Cable One is a cable company operating cable television systems used to provide cable television internet access and voice over internet protocol services. Cable One, since the 1980s, has been locally assessed as a cable company in the state of Iowa until tax year 2009, when the department determined that Cable One was a telephone company. Cable One may only be subject to central assessment if Cable One meets the statutory definition of telephone company. A statute must be construed to give effect to its plain language. 3 different authorities, the administrative law judge, the State Board of Tax Review, and the district court, applied the rules of statutory interpretation and determined that Cable One is not a telephone company under Chapter 433.
Would you agree that we don't owe any deference to those determinations? We're deciding this de novo.
I would agree that the court does give some deference to those decisions, but it is for this court to determine the law. Each of these authorities concluded that Cable One's provision of interconnected VoIP service over its cable television system could not transform Cable One from a cable television company into a telephone company under Iowa law. The district court's decision is legally sound, and the department has not carried its burden to show otherwise. The district court's ruling should be affirmed, and the state board's order should be upheld in all respects. In addressing some of your specific questions to the department, I think it's good to step back and look at the law. Central assessment, there are only 6 categories of property that can be taxed. The 2 that are important here are commercial property and utilities. Telephone company, falling under the utilities section of the law, are subject to central assessment. Commercial property is subject to local assessment. Cable television property, as post-Newsweek found, is commercial property and continues to be deemed commercial property.
Is there a part of your cable network that is not taxed locally?
No.
Oh, what the state wants to tax, you're already being taxed locally?
Yes. Under local assessment, the entire cable property that is subject to tax is taxed.
Including those PS, whatever he was talking about.
If you're referring to the embedded modem terminal adapters, which are a box that customers buy in order to receive voice over internet protocol services that are designed to receive internet protocol type communications, whether that be from the internet for internet access services purposes or VoIP telephone calls, that is intangible property, and that is not subject to taxation under local assessment.
Is there anything installed on your lines outside the consumer's home
Cable One,
That's not taxed by the local authorities.
well, in all due respect, Your Honor, Cable One does not have lines. It has a broadband television network, which is bandwidth. And all of that is taxed under local assessment, yes.
If it's, at the end, if we ruled for the department, you're not going to get double taxed under our law, right?
Well, technically, it sounds like we would, yes, absolutely, because there can only be, property can only be subject to one tax. If the department's permitted to tax what it calls the telephone service portion of the property, that is the cable television broadband network.
Right. I mean, you call it the cable television broadband network. The operative word in the statute is lines, right?
That's correct.
And as far as coming into my house, it comes into my house on a line, right?
No, I would disagree. It comes into your home on a cable drop, and as the Cox cable case cited in this case, the cable drop is taxed as cable property. It's not a line, and line is not defined in the statute under 433.
All right. I mean, maybe we don't want to get hung up, but there is a coaxial cable that's in the communication zone of the telephone pole outside of my home, next to the CenturyLink wire, correct? And they both come into my house, and they're both cables, right?
There are pipes coming into your home.
Right.
That's
They're
correct.
both, these two pipes come into my
They're
house.
very different.
All right, but they're very different. But if I go to MediaCom, I can make telephone calls on the cable one, and if I go to CenturyLink, I can make telephone calls. I can make telephone calls on the CenturyLink one, right?
Yes, I would clarify, though, with respect to the discussion earlier regarding MediaCom, the court needs to understand that MediaCom has elected to create a separate subsidiary that is indeed a telephone company and is authorized by the Iowa Utilities Board to provide telecommunications services, local exchange service, inter-exchange services. Cable One does not provide those types of services. It is not authorized to provide those type of services, and it has no right under the law to interconnect with other telephone companies like MediaCom does. That's the benefit of being a telephone company, which Cable One is not elected to become.
How do you connect with other telephone companies then, if you're not a telephone company?
We have to go to a third party that is a telephone company, which is level 3 in our case, and hand off our IP traffic in IP to a level 3 company that has IP interconnection capability. Level 3 then converts the IP traffic to TDM, which is public switch telephone network technology, which allows it to run on the PSTN in order for it to be terminated, either to terminate or to receive. There was some discussion earlier about how everything that a Cable One customer has in their home is the same as MediaCom or CenturyLink. That's absolutely not true, because if you look at the definition of voice over internet protocol that is established by federal law under both 47 USC 153 and 47 CFR 9.3, you see that VoIP has a very specific meaning in the law, and that is that it requires additional equipment in your home that you could purchase yourself or you could purchase from a cable company in order to receive those calls. So it's not exactly the same. Did I answer your question?
I think so.
Okay. I apologize if I...
Counsel, do we need to find or determine what the primary use of the cable pipe is?
Primary use is only necessary in this case if for some reason you were to reverse the district court, which we see no need to do because the decision was well-founded based upon statutory interpretation. However, should you reverse the district court, you would have to look at the primary use of Cable One's property, because there can only be one category for a single piece of property. In this case, the property that is used is the cable television broadband network to provide both VoIP services and cable television services.
What language in the statute allowing central assessment provides for a primary use test.
Well, if you're asking me the question with respect to 433, I think that it's not specific to 433. What you have to do is you have to step back as 433 in the context of the entire statute and look at superfluge, which did a nice job of taking the entire statute and saying, look, there are 6 categories, and property has to fall into one of these categories. And there can only be a single use for each property for taxation purposes.
Is there a federal preemption obstacle to state central assessment?
No, I believe that the department has misconstrued counsel's briefs throughout these various proceedings. Actually, what counsel has tried to explain is that when you have terms that are not defined, like a line, Iowa law recognizes that when a term is peculiar and has a specific meaning, you need to look to how those terms are defined elsewhere. And in doing that, this court and the district court and the ALJ and the State Board of Tax Review was asked to look at the federal law. Why? Because federal law has defined voice over internet protocol services, as I previously mentioned. Federal law has also determined what a line is for the history of telecommunications. So, for example, about 10 years ago, when voice over internet protocol came into the market, the Federal Communications Commission was trying to measure broadband in the marketplace. And it started asking companies that were in the business of providing broadband, tell us how much you're providing. Well, when it turned to the telephone companies, it says, we want to know what how many access lines do you have? And that's how telephone companies report. And then when it turned its questionnaire to the cable industry or other broadband providers like cable companies, it said, tell us how many subscribers you have, because it understood that bandwidth is not lines. So it's not a question of preemption of taxation. States have the right to tax. It's a question of looking at the federal law to help define things that are not otherwise defined by state law.
How do you, there's a decision that I think you argued, looks like you're on the case in Arizona, written
Yes.
by my former law partner of many years ago, that kind of rejected your arguments. Is that decision just wrong, or is it distinguishable?
Naturally, I would say that that was an error of law. And unfortunately, in the state of Arizona, you file a petition for review to the Supreme Court, and they do not have to take your case. And I think less than 1% of or about 1% of the cases are taken, and ours was not. The error of law, first of all, for purposes of this case, whether Cable One is subject to Chapter 433, the ruling in Arizona is irrelevant, because that statute concerns whether you're a telecommunications company using communications facilities and providing public telephone, telecommunications exchange, and inter-exchange access. Just as an aside, the error that the court made was that it was a panel of 3, is that they looked at public telephone, telecommunications exchange, and inter-exchange access and said, oh, well, you know, those are specific terms, peculiar terms. They deserve, not common usage, but how are they used? And then abandoned that statutory interpretation rule and said, well, that's local telephone service and long-distance telephone service. You provide it, so therefore you are. And if anybody were to read Judge Green's decision of the breakup of AT&T and all of the law that followed thereafter by the Federal Communications Commission, telecommunications exchange and inter-exchange access are very specific terms of art. And that was abandoned in that case. But that statute's about services, not about whether you are a telephone company owning or operating a telephone line, as Chapter 433 is. other questions. I think that I mentioned, I just, I think I caught all those. Okay, we talked about the Arizonans. I'd also like to, it's true that a statute may encompass a new company or a new technology coming into existence subsequent to the enactment of the original statute. This court, however, has held the maxim to be true only if the terms of the statute are comprehensive enough to include the new company or business. Consistent with this court's decisions, both the State Board and the District Court found the rule in Bruce transfer applies only where the unforeseen technology or process comes within the general purview or scope of the statute in question. The State Board correctly determined that the language of Section 433 is too narrowly written to impose central assessment on Cable One. Oh, I'm sorry, I apologize. My time is up.
Want to take a second to sum up and?
Yeah, in sum, the district court correctly found that the department's reclassification of Cable One as a telephone company is a violation of law, and that the department has not met its burden under Iowa Code Section 17A.1910. Cable One requests this court affirm the district court and uphold the State Board's order in its entirety. Thank you, Your Honors.
Mr. Miller?
A couple of things I'd like to get to. One
Well,
of
before you
which-
get to anything, tell me what's not taxed locally and what is taxed locally, and whether there is any double taxation.
No, there's no double taxation. What Cable One is confusing when they're talking about these categories and stuff, they're saying Cable One is a cable company, so therefore we're in a category of commercially assessed property. What is assessed is the property, not the entity itself. An entity can have two sets of property. Cable One can have their cable video property, which is assessed locally, and then they can have the property that's related to the provision of the telephone service.
Let me interrupt you because I know you only have a few minutes. The local assessment is based on value, right?
Well, they both are.
And yours is based on value too of the, you would break out the value of the telephone lines, or the telephone company because they operate lines, and assess that separately?
No, the department assesses telephone operating property. A company that's providing telephone property would be assessed as a unit on the value of its telephone operating property. Now, we've had cases before, they've never gone to court, but where the companies have come in and argued that we are double assessing and stuff, because that gets kind of tricky as to what's the local assessment and what the central assessment is. But that's not unusual, and that can be worked through. It always has been.
I think what the court is driving at, maybe what Justice Wiggins is driving at, and it concerns me too, is would there be a scenario under which the very same piece of property could have to pay both a local tax and a state assessment?
Potentially that could happen, because it'd be the cable line itself that's covering both the cable TV and the cable and the telephone service that's going across. So you wouldn't double assess that or double value that line, and that always has to be taken into consideration. But in this particular case, you have $900,000 in telephone equipment that was added by Cable One. That none of that $900,000 ever got reported to the local assessor, and it's not being picked up now because that's telephone property. If it was related to the video portion of the company, then the local would be picking that up, and there could be an issue there. But that's not happening in this case. It's not unusual for a company like a central telephone company will have operating and non-operating property. In the Cable One case, its non-operating property would be the property that's associated with the video services. The operating property would be the property that's associated with the telephone services. And like I said, historically, for the cable companies that transition into telephone service, the department has always made sure that the local assessor is picking up the full value of that cable. That's why our assessment was only $671,000. The local assessment for Cable One is, between the 3 assessing jurisdictions, was close to $3 million.
So what you're saying is that this property in particular, you're confident is not being assessed locally at this point in time?
Yes, that's correct.
In general, I mean, what I know about state and local taxation can be filled in a thimble, but in general, local counties don't tax personal property, do they?
No. Central assessment, though, for telephone companies can. That's why the EMTAs can be subject to central assessment. And any personal property items that Cable One uses to provide the telephone service would be subject to assessment, whereas if it was a video function, solely a video function, it would not. I'd also like to point out that the Cable One case in Arizona, we think, is very relevant here. And the statute is really quite strikingly similar. The Cable One defines a telecommunications company as any entity providing that owns communications transmission facilities. Instead of using that term, Iowa uses the term line and all property associated with the telephone business. That's the same thing. The service that's being provided is both a two-way communication service between 2 points. We would submit that if Cable One meets the Iowa definition of telephone company, it's going to meet the Arizona definition and vice versa.
Thank you. At this time, we'll consider this case submitted together with the case of State of Iowa versus Halverson, the non-oral case. You may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.